What is going to happen at a 341 meeting of creditors for a Chapter 13? So, first, let's talk about where this comes from. This is straight out of the Bankruptcy Code. There is a hearing that is required where the Chapter 13 trustee is basically going to make sure that the documentation, the petition that was submitted to the court is true and accurate. And they also get the opportunity to express their objections. Now, a lot of clients will totally freak out when they hear the trustee say, well, I object to paragraph blah, 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 or I'm going to object to this, I'm going to object to that. So the trustee is basically an attorney who has been hired by the United States trustee to advocate for keeping your petition in line with the bankruptcy code. They are not a judge. So there's no need to freak out. About a week after the 341 hearing is over, you're going to get a list of these objections in the mail. Again, don't panic. Now, in the Northern District of Georgia, all of the hearings are conducted by Zoom. Now, don't think just because this meeting is being held over Zoom that you can just be kind of sha la 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 all about it. No, this is a hearing where you are testifying under oath. This is a court hearing, and when you do it, you need to be in a quiet place. You need to be where you have good, solid internet so you'll be able to finish this meeting. Please do not ever try to do a 341 meeting of creditors while you are driving. If you do, there's a good chance the trustee is going to express some extreme frustration with your foolishness, and the hearing will most likely have to get reset to a different date. You can't do it while you're driving. Come on. All right. So let's get into some more things about the hearing. The trustee is going to ask you questions. And the main question is, when you're represented by an attorney, did you meet with an attorney, virtually, live, whatever? Did you review the petition and make sure that it's true and accurate? Every now and then, there'll be some uh, law firm that files a lot of cases nationally, big, huge. They don't even get an attorney to look at the petition with the client. They'll file the case, and the trustee goes ballistic. Can't do that in the Northern District of Georgia. If you are represented by a law firm, that petition better be reviewed with you by an attorney, period. Okay. Next question. Are you currently suing anybody? Workers' comp, personal injury, anything like that? Why is the trustee asking this question? Well, the reason is all of your assets have to be listed on the petition. And in Georgia, if you're suing somebody, for some car wreck from a few years ago, any type of lawsuit, discrimination at work, whatever it is, it better be listed on your petition as an asset, because if it's not, it's going to be automatically legally deemed a value of zero. That's very bad, very bad. The trustee is also going to ask you questions about your paycheck stub. They may ask, hey, do you get, bonuses every quarter? They may see something on your tax return. Yes, we are required to submit your tax returns to the trustee ahead of time so they can ask you questions like this. Hey, I saw you got a bonus last year. Do you expect to get one this year? They're going to want to know what's going to be done with it. Those are the types of questions you're going to get. The hearing will probably last maybe 5 minutes. Again, it's nothing to freak out about. If you're represented by a law firm, there's going to be an attorney on the line with you. Now, here's one of the number one points I want to make. When you're answering the trustee's questions, do not make guesses. Okay. It's okay for you to say, I don't know the answer to your question. If the trustee wants you to guess, it's okay to say, oh, okay, my best guess is blah, 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 whatever it is. But if you're nervous and you're feeling a lot of anxiety, the biggest mistake you can make is to say something that is not factually correct. Now, has that happened before? Well, yes, I've been doing this since 1998. I've been doing this a long time. And yes, it has happened where a client has gotten nervous, said something stupid that was completely contradictory to true reality, And how did we fix it? We had to go back and do an affidavit, get it notarized, blah, blah, blah. If the trustee wanted to, they could, if you're trying to correct testimony, they could make you appear live at your confirmation hearing. And in Atlanta, that's a really big pain in the fanny to have to appear live in court because going down to the Richard B. Russell building is oppressive. You have to pay a lot of money for parking. You have to spend a lot of time going through security. And then you have to wait around pretty much more than half a day for your hearing to be heard. Long story short, don't make unnecessary extra work for you and your attorney. Don't answer the question unless you know the answer. Don't get diarrhea of the mouth. Don't do that. Just stick to the answers. If the trustee wants more detail, they're going to ask you for it. Yes, absolutely. You have to tell the truth to the best of your ability. There is no bankruptcy case on planet Earth that is worth committing perjury over. Not worth it. Stupid. Tell the truth, um, be as concise as you can. And if the trustee wants more detail from you during this hearing, they will ask. Now, who's going to show up at this meeting of creditors? Well, it's called a meeting of creditors. So, can the creditors show up? Absolutely. Yes, they can. Will they show up to the hearing? They almost never do. It is possible when you borrow money from finance companies, those guys tend to show up because they'll might object to whatever value you put on whatever the collateral is. If you have an ex-spouse that you're paying alimony, child support to, or anything like that, they have to be listed in your petition. And I will say it is kind of common for, especially when there's it was a nasty divorce or something and it's pretty recent, that spouse can show up and ask you all kinds of questions under oath. They may show up to your 341 meeting of creditors, but as a general rule, creditors just do not show up to this hearing. In the Northern District of Georgia, we're required to send a copy of your driver's license and social security card to the trustee ahead of time. You don't have to show those out or anything during the meeting of creditors right now, but you might want to have them handy just in case, but there's no documentation that's required for this hearing. Okay, so again, let's do a quick recap of what's going to happen after this hearing is completed. About a week or so later, you will receive an objection to confirmation in the mail. Do not panic when you get the objection to confirmation. It does have some pretty scary language in it. Sometimes part of that standard language is, trustee may move to convert you over to a Chapter 7, things like that. Again, don't panic. If you've got questions, call your attorney. It is very common to get objections on every single case. If you get no objections at all and your case gets confirmed right out of the gate, that is super extremely rare. If that happens, you need to buy some type of cake or reward or something for your attorney because that would be outstanding. But again, the 341 meeting creditors, nothing to panic about. This is the first step in the process of getting your case confirmed. Confirmation hearings will be the next step, and those typically occur about 6 weeks after the 341 hearing. Thank you so much for tuning in. And if you've got any questions, please check out my website, kellycanhelp.com. I've also got a YouTube channel, Kelly Can Help. And again, I thank you so much.